All right, our next case on the docket this morning is ARR Investments versus Bautista.
Good morning, Your Honors. May it please the Court. Can you hear me okay?
Absolutely.
Dorothy Easley on behalf of AR Investments. I'd like to reserve 5 minutes for rebuttal.
Got it.
And briefly, I know that the Court has studied the record, the briefs, and the law thoroughly. So what I've tried to do is structure the oral argument around the areas where I think the courts will have questions and concerns, and rest on the briefs for all remaining points. And I know that before I go into each of the 4 points, there are 4 irreconcilable and irreparable, unrepairable gaps and transfers at issue here. And I want to briefly outline them, just give you the overview, and then go into each one of those with specific record sites. The first is the conflict in the transfer from Doral Bank Corporation to Doral Recovery LLC, which I'll detail in just a moment. The second is the conflict in the transfer from Doral Recovery LLC to the FDIC, which is a nullity. I'll explain that in detail in a moment. The third is the conflict in the transfer between the FDIC and Bautista Cayman Asset. The fourth is the conflict in the transfer from the FDIC to Bautista REO. And before I turn to each of those, I'm mindful of Charlie Munger, Vice Chairman of Warren Buffett's Berkshire Hathaway, who once said something like, "You can't trust the bankers to control themselves." And so the Adele Goriel decision from this court, Fielding, Kahn, Richards, all from this court, and then other courts like Barnett Bank and Vidal from the other appellate courts, all explain why the debtors and the creditors have to be controlled by Florida's courts. So with that, let me go to what I can believe is the largest and irreconcilable and irreparable transfer. And that's the first transfer from Bautista, Doral Bank to Doral Recovery LLC. And just to give you the specific record sites I'm relying on, record site 940 is in the 4th amended complaint, Exhibit A, attached as an allonge number 1. It's Exhibit A, allonge number 1. There's no execution date. It is ostensibly effective 5/1/13. The second document, record site 941, record site 1108-10, in the 4th amendment complaint is Exhibit G. That is the assignment from Doral Bank to Doral Recovery LLC. It is undated. I know the summary judgment gave it a date. It is sworn to March 24, 2014, effective 5/1/13, recorded 4/4/14. But note, there's no Exhibit A to that assignment. There are Exhibit A's to all the other assignments. What is the problem with those documents? The problem is we have irreparable conflicts between those 2 documents I just cited with the record sites and the Exhibit A, allonge number 2, from Doral Recovery to the FDIC, record site 941, stating that as of 2/27/15, Doral Bank Corporation, quote, owns, close quote, the note, and this, quote, shall be documentary evidence, close quote, of the same. The other problem is that those exhibits conflict with Exhibit H, Doral Recovery transfer to FDIC in 2015, record site 1011, stating again that Doral Bank, quote, owns, close quote, this note, and, quote, shall be documentary evidence, close quote, of the same. But
Counsel,
there are more
I'm going to
problems.
interrupt
Yes,
you.
Your Honor.
I'm going to interrupt you just a moment here in your points, which are very well laid out. But there was an assignment from Doral Bank to Doral Recovery of this
Correct.
note that
Correct.
was effective before the complaint was filed.
It states that it is effective, it is undated, correct, Your Honor.
And it was recorded, the assignment was recorded
The assignment-
before the complaint was filed.
The assignment does have a stamp, and I think I know where Your Honor is going, but let me not jump.
So is it your contention that because there are other documents, for instance, the Fourth Amendment complaint, the allonge perhaps, but let's say we don't worry about the allonge, we just look at the Fourth Amendment complaint, which references Durrell Bank owning the note,
Right, the paragraph 17.
right? And then we look at Durrell's bank's records, which reference they still own the note.
Correct.
Are you saying that that creates a conflict in the evidence in which summary judgment was not appropriate?
I'm saying yes, Your Honor, and I'm saying more than that. The conflict is irreconcilable and unrepairable. And I know Your Honor studied the record, but just belaboring, that assignment was not attached to the first complaint, the original complaint, or the second complaint. It was attached to the second amended complaint, the assignment between Durrell Bank and Durrell Recovery LLC. There are assignments attached to the original and the first amended complaint. Those are assignments relating to the 2003 loan that ARR Investments had already paid off, the $1.5 million loan. So under the Kahn decision, under Richards, which specifically looked at both assignments and allonges, under the Corey decision, the Barnett decision, the Vidal decision, we have irreconcilable conflicts, and we submit not only was summary judgment improperly granted, but we are entitled to involuntary dismissal. And that's our position as to the first. That defect is so fatal. Now, it's important also to underscore, these aren't documents we presented. These are documents that Bautista REO presented with its complaints, with its pleading, the Fourth Amendment complaint, and that these are documents that they relied on attached to their motion for summary judgment that makes these conflicts unreparable.
In a case involving a lost note, which this is,
Correct.
what is the relevance or significance of an allonge?
Well, the Bautista REO says the allonges don't matter, and then our response to that is, we didn't put the allonges into the record, you presented the allonges. So from an evidentiary standpoint, they've presented those to support their summary judgment. But to further answer Your Honor's question, you raise another good question. If the note's lost and the allonge is supposed to be part of and attached to the note, why in the world are they presenting allonges this late in the discovery period when the note's lost? Where did those come from? And more importantly, which I think Your Honor is also raising as a very important point, these allonges, most of them are backdated. And Vidal came down very hard on the backdating of documents. True, Bautista REO takes the position that backdating is not illegal. Not illegal. It makes the documents suspect, and as the Vidal court pointed out, the 4th District, these backdated documents are antithetical to the assignment having the standing at the time the original complaint is filed. So to further address the bigger picture, the big point here, because of these irreconcilable conflicts between standing, Durrell Recovery could not have standing at the time of filing the original complaint in 2014 because it did not have the right to enforce the note. And in the lost note case, which Your Honor points out, your rights are derivative. Your rights derive from the proper allonges and assignments. And if you don't have the standing to enforce the note at the time of the original complaint, that's peg number one that's missing. Then, well, do you have standing at the time of your summary judgment, the Fourth Amendment complaint? And the answer to that is, if we believe Bautista REO's allegations and attachments to be taken as true, which we must do, then Bautista REO does not have the derivative standing because their whole theory of liability, I got loads of charts here, their whole theory of liability was based on a transfer from Doral Bank Corporation to Doral LLC, then from Doral LLC to the FDIC, then from the FDIC to Bautista Cayman Asset, then Bautista Cayman Asset to Bautista Financial Holdings, then Bautista Financial Holdings to Bautista REO. My arm's not long enough. But the point is, if Doral Recovery, whatever they assigned to FDIC, they weren't assigning their right to enforce the note because they didn't have it. Doral Bank had it. And to the extent that Bautista REO is arguing that Doral Bank Corporation and Doral LLC are one and the same, their own corporate representative, Dennis Steppelman, testified in his deposition recognizing they were separate. Doral Bank filed a 2013 federal court action that they dismissed in 2014, stating that it was separate from Doral Recovery LLC, and all the attachments to the complaint. The allonges, the assignments, all treat these entities as separate and distinct entities, and they've never been pled, let alone evidence produced.
Understanding that Bautista REO may have attached the allonges to its pleadings or to its motion for summary judgment, isn't the real question what the legal effect of the allonges is as opposed to the legal effect of the assignments? For example, if you take a photocopy of a lost note and stamp an endorsement on it, that's not how you negotiate or transfer the note. So the same would hold true of an allonge. If you attach an original allonge to a lost note, to a photocopy, that doesn't do anything. It has no legal effect.
Right, Your Honor.
So don't we really need to focus on the assignments as opposed to the allonges?
Your Honor, I'm afraid that this is a very good point, and in the interest of accuracy, I think that we can't simply ignore the allonges. I think they're important because they've been placed into the record, and we can't simply whitewash the record and pretend that they don't exist. What they do show is a pattern and practice of documents with backdated effective dates to fit different stories. And if Your Honor will indulge me, I will go into the other 3 transfers that further underscore this. Have I answered your question, Your Honor?
Yes, I mean, I'm focusing on the legal effect, not whatever factual effect that Bautista REO may think they have.
Correct, Your Honor. And I do agree with that point. It's just, it's right, these are the elephants in the room. And I don't think that they should be ignored. I think they further underscore why reversal of summary judgment and involuntary dismissal are not only correct on the law, but they're also correct on the equities here, because there's something there's something really fishy going on. So going on to the second transfer between Doral Recovery and FDIC, that is a nullity for the first reason being that Doral Recovery, when it assigned something it didn't have in the first place, like me assigning the Brooklyn Bridge. The other problem is, in referring to the Exhibit A, allonge number 2, that's record site 941, stating that as of 2/27/15, Doral Bank owns the note. Exhibit H, record site, let's see, what is record site Exhibit A? Anyway, 1011-14, stating that it's effective 2/27/15, recorded October 12, 2015. It's the assignment from Doral Recovery, answering Your Honor's question, the FDIC, that also states Doral Recovery does not own the note. It underscores that Doral Recovery doesn't own the note. It doesn't expressly state that. It says Doral Bank owns the note. So again, looking at the allegations in the third and fourth amended complaint that Your Honor referred to, the paragraph 17, the Doral Bank on the note, that's the other defect with that transfer. So that transfer is defective. And again, underscoring that the transfers that follow thereafter are defective because their rights are derivative. But there are more defects. The other problem is the authority, which we did raise, and I'm happy to, there are at least 20 record sites that I'm happy to give the court regarding raising objections to the authority and authenticity problems with these documents. But Dennis Stratford, who was noticed for deposition as the corporate representative of Bautista REO, and noticed as having the most knowledge, record site 2085-86, he testified he didn't even know who Robert Chafalo, the one signing these documents, is. Doesn't know him from a hole in the wall. And the document is notarized in Texas, but Doral Recovery is a Puerto Rican company, so we don't even know anything about these documents. And again, taking those allegations as true, those allegations further under Kahn and Richards show the irreparable, irreconcilable conflict. I see that I'm in my rebuttal time. Unless the court has a specific question for me at this time, I'd like to reserve my remaining time. Thank you, Your Honors.
Thank you, counsel.
Good morning, Your Honors. Denise Del Powell on behalf of Bautista REO US LLC. I'd first like to address the point of the allonges versus the assignments. As stated, an allonge cannot be, or endorsement cannot be attached to a note that has been lost. You don't have the original anymore, but the courts have stated that you can establish ownership by assignment. And we cited to 3 cases in our briefs for the proposition that a written assignment of a note and mortgage properly transferred the note and mortgage. And in this case, and I think an easy chart, which is part of the record at 3445, shows the transfers both by assignment and the allonges through each stage of the process. And in each assignment, not only with the mortgage and other documents referred to, it also refers to the assignment of the note. Now, counsel...
Counsel, I'm going to ask you about the initial standing issue. So we have an assignment from Doral Bank to Doral Recovery, and that was recorded. It's an assignment. I think that's pretty clear. But then after that, we have numerous references to the ownership still being by Doral Bank. There are references to that, not assignments, but references to that throughout the record. Now, the lower court decided as a matter of law, those did not matter.
I think what she said was, as a matter of law, what's reflected in someone's books does not control. It's the assignments that are of record that control. And in this case, you have the assignment from Doral Bank to Doral Recovery, and then the assignment from Doral Recovery to then now FDIC, who's taken over as receiver.
And so, as a matter of law, all the other evidence that was presented in essentially the documents filed with the summary judgment that reference they don't actually hold this note should be disregarded.
Correct.
As a matter of law.
Correct.
Okay. And you don't think that creates any issue of fact?
Well, I don't, because when you look at what is on the books and records, from a legal standpoint, what controls is the assignment. And what the assignment from Doral Recovery to FDIC is effective as of February 27th, which is later than the original complaint was filed. So at the time the complaint was filed, Doral Recovery had standing to file the lawsuit because it had been assigned the loan documents and the note. What the appellants try to do is say all these nefarious things are going on, but they present no record evidence. And the record evidence is in the affidavit of Kevin Shea, which is attached to the summary judgment, which establishes the various assignments and allonges, as well as the second affidavit in which he talks about the power of attorney, and also talks about the fact that pursuant to the loan sale agreement with FDIC, there was the ability of Bautista to designate up to 2 entities to transfer the loans to. And they exercised that right, and that is attached, the assignment is attached to the second affidavit of Shea. So appellants say, well, the loan sale agreement was only with this particular Bautista entity, so it's invalid. But it's not, because Bautista had the ability to transfer up to 2 designees, which it did, and which is reflected in the third assignment, which is at 2959. So if you look at each of the assignments and the allonges, they have the same effective date, and counsel makes, oh, well, they're backdated. Well, that's not unusual in these commercial transactions, and appellants have shown no nefarious reason. They just say something without any record evidence, and pursuant to the affidavits, that's the evidence that was before the court on summary judgment. So standing on the date of the filing has been established. They also talk about denying the signatures on the various assignments. However, in their, I think, fifth affirmative defense, it's just a general, they lack standing upon information, belief, lack standing. They don't challenge the signatures on the documents. And in the Riggs versus Aurora case, it talks about the fact that there was nothing, they didn't challenge the signatures as part of their affirmative defenses or pleadings, so were precluded from doing so later on in the case. So based upon that, they cannot challenge the signatures. They also talk about the discovery process and the fact that they were still trying to get documents and trying to complete discovery. If you look at the record, corporate representative depot was taken of Bautista on May 22nd, 2017. At that time, the appellants produced a copy of the loan sale agreement and in fact questioned the corporate representative of Bautista on the loan sale agreement. However, between that time and the summary judgment hearing, which was February 9, 2018, they made no other effort to engage in further discovery on that issue. In addition, at the time the second Shea affidavit was filed on September 22, 2017, attached to that was a power of attorney. Between that time and the summary judgment hearing, they did not take any effort to depose Mrs. Graves, to serve any written discovery on her, and because of that, they have waived their right to preclude summary judgment because they basically just sat down on their discovery and did not effectuate the discovery. Excuse me.
I'd like to ask you about the power of attorney for Ms. Graves, because they've brought up an issue with her leaving the company perhaps prior to the power of attorney being executed. Now, I don't think there's any argument that she was not an employee at the time the assignment was done, but just that there's no documentation to prove that other than this power of attorney form, which was arguably executed perhaps after she left the company. How would you respond to that?
There's no record evidence that she was not with the company at the time that she signed it. Mr. Stratford was asked that question at his deposition, I believe, but you can't just come in and say, oh, she wasn't an employee. Okay, prove it, take her deposition. Subpoena the employment records from the appellee. None of that was done. So there's no record evidence that she wasn't an employee at the time that she exercised her powers under the power of attorney given by the FDIC. I think another issue that was raised was the issue of adequate protection. And under the summary final judgment, the court required an indemnification and said that the plaintiff would indemnify if a third party came aboard or came forward and tried to say they were the owner of the note and to enforce the note. And based upon, and the court reasoned that it's been almost 10 years since this note was lost, and nobody's come forward in 10 years, so a written indemnification is sufficient. Appellants try and argue that we didn't offer up any adequate protection, but it was offered up in the first Shea affidavit, and it's also contained in the summary final judgment. And so, unless there are any questions, we believe that the trial court followed the law in entering summary judgment, and we ask that it be affirmed.
Questions?
Questions? Okay, thank you, counsel. Okay, just over 4 minutes.
Thank you, Your Honor. To answer your question, Your Honor, one of your first questions, the fundamental problem with the transfer of the FDIC and BCA does have to do with the limited power of attorney. It's important to underscore that that limited power of attorney document was presented in redacted form after summary judgment was filed, after the close of discovery. We saw that for the first time. And that limited power of attorney document, first of all, in opposition to the plaintiff's motion for protective order, once the document was produced, the defendant, ARR, requested leave of the court to take depositions on the document. They also wanted Capital Crossing's employment records because Dennis Steppelman did testify that Kevin Shea, or the corporate representative of Capital Crossing, forgive me, did testify that she left in October or November of 2016. She executed that limited power of attorney in 2016, October 2016, October 31. So it's possible she was no longer with Capital Crossing at the time. But the other significance of the power of attorney is, and this is not simply consistent with Florida, it's consistent with New York, with Texas, with Puerto Rico, because I wanted to make sure I was advancing the right law. Powers of attorney are strictly construed under him. Powers of attorney have to expressly include the ratification of prior acts, or there has to be evidence of ratification of prior acts. This transfer, this assignment, and the allonge that she signed is effective as of March 2015, more than a year before the power of attorney was executed. So as a matter of law, by Florida statute, powers of attorney are effective at the time that they're executed and going forward. You can't retroactively ratify something when there's no express language and no evidence to support it. So the transfer from the FDIC to Bautista Cayman Asset is a nullity, first of all, because they didn't have anything to transfer in the first place. Secondly, it's a nullity because that power of attorney is a nullity, and it's yet another retroactive document. The other points I'd like to address are the preservation issues. We did raise the issue of standing. This is not the plaintiff's first loan enforcement case. They know full well that standing includes authenticity and authorization to sign the documents. But let me give the court more record sites on how the authenticity and authority to sign these documents was raised. It was raised in paragraph 16 through 25, record site 1063-64, in ARR's motion to dismiss the third amended complaint, record site 592-602, more specifically 597-600, in the ARR's answers to requests for admissions, paragraphs 6 and 7, they denied these change of assignments, and that plaintiff was the owner and holder of the note, record site 1153-156. I know these are recorded, so you can go look them up. Your law clerks can look these up and check me on it. In addition, the pretrial statement, we again challenged that in the lack of authentication, the improper officer executing the document, the improper person executing documents, the missing corporate seal, the insufficient number of witnesses, and reserving additional objections, record site 3243-47. In addition, Your Honor, this transfer from the, my time is up. May I answer any questions for the court?
Any questions?
Then we would request that the court reverse summary judgment. At a minimum, we respectfully request involuntary dismissal because of these irreparable conflicts. And thank you for your time.
Thank you, counsel.
Thank you.